having had our coffee break, we strengthened to continue with business and human rights after trade human rights. I think we've covered quite a lot of ground already in the various panels we heard so far. And the specialty of this panel is not only that we have very distinguished speakers, but also that they're all somewhere else. I now see them on the screen. Thank you to the technical team for allowing them to join in here in Vienna. I would like to send them my warmest greetings. Yuval Shany, Markus Krajewski, and Michelle Ratton, Sanchez, Badin. And if I may, I would just turn to your first names for the sake of easiness. You're right. Business and human rights was covered to some extent. First off by the High Commissioner. Second, of course, in the keynote panel, we already covered technology and human rights to some extent. But we now, if I understand correctly from those who conceived the whole conference, we go a bit more in depth in the various topics. And if I may, I would start with Yuval Shany. Yuval is the Hersch Lauterpacht Chair in International Law and former Dean of the Law Faculty of the Hebrew University of Jerusalem. He was a member of the UN Human Rights Committee from 2013 to 2020, and he served for 1 year also as a chair of the committee. He currently serves as a senior research fellow of the Israel Democracy Institute and a co-director of the Center for Transnational Legal Studies at King's College. Yuval will share his insights on digital rights and their implications for business and human rights. So there's a very nice connection between the very first panel and the questions on diligence and so on. And if I may request actually all speakers, since we are running late, to be very, very precise with regard to the timing, and might actually go at the cost of the question-answer period if we don't manage to be within schedule. So with that somewhat impolite request, but you have all sufficient experience with conferences of this kind that I think you will understand where I'm coming from as a chair. Yuval, the floor is yours. Thank you.
Thank you very much, Ulrike, and thank you. I mean, I want to thank the organizers for inviting me. I wish I could be with you in person, but it was difficult. I only landed this morning to London from another destination. I will share a screen and go directly, in the interest of time, into my presentation. So the first point which I would want to make concerning digital rights and implications for business and human rights is that the question of how do we protect digital rights in a business and human rights framework is very much related to the general concerns that we have about the business and human rights framework and its adequacy to effectively regulate businesses. The claim that I will be making is that for companies that provide digital services and effectively control digital rights, this is a particularly critical connection that needs to be explored. And in a way, in the realm of the claim that I would make that in the realm of digital rights, actually companies may be much more important than states, and therefore the need to find an effective framework to govern their activities is absolutely crucial. And secondly, I will discuss two notable attempts by digital companies that uphold digital rights and by UN bodies that enforce digital rights to try to basically extend existing frameworks to private businesses that afford digital rights. So the first point is, of course, quite basic, right, rudimentary, and it is that the international human rights law, which is the general normative frameworks for all rights, including digital rights, is a state-centric framework. It is comprised mostly of treaties that place obligations on states. These obligations are due to other states as well as to individual right holders. Compliance with these obligations is monitored by interstate bodies, be they at the regional or at the UN level. And we also know that human rights law, international human rights law, has very close and direct connections to domestic constitutional law, which in many countries is also very state-centric, namely that it mostly regulates the activities of governments. I am aware that there are some countries, including German-speaking countries, where a broader framework has been employed, but this is not the norm around the world. So according to this framework, when one is dealing with businesses that violate rights or that violate needs and interests that are held or that affect right holders, the main avenue by which one will deal with it would be through what we call positive state obligations. I mean, the state would have to basically insert itself between the company and the individual, regulate the activities of the company in order to protect the individual. So this is always true for business and human rights. This is not new. The claim is that with regard to digital businesses, we are talking about a new power configuration, which puts these companies in a unique position in that they control the exercise of key human rights. So I will deal very briefly very soon with Meta and with its human rights policies. Arguably, the policies of Meta are much more influential with respect to freedom of expression around the world than the policies of most governments around the world. So the fact that these companies have these huge, not only huge economic power, but also huge interface with users and with the way in which users exercise their rights, of course, transforms them into something which is more than the ordinary cases that we have studied in business and human rights before, such as the extraction industry or companies that inflict environmental harm. Here, the connection to rights is much more central. These companies also have an exceptional capacity to enforce policies. So it would make much more sense, again, with the Meta example, for Meta to uphold rights, to ensure that speech is exercised or that hate speech is suppressed, than to actually expect a state to intercede and enforce these policies. And like with other very big companies, when we're talking about big tech, we do have here unique regulatory challenges, given that these companies are often too large and also too global to regulate, since they do operate all around the world and are not subject to intensive regulatory power of most states. There are also questions regarding regulation and technology, which I do not have time to delve on, but that has to do with the question of when is the right time for states to intervene and regulate when technology is actually developing, because there are concerns, of course, that over-regulation would stymie the development of technology. The business and human rights framework would apply also to technology companies. This is a well-known framework. I don't think I have to spend much time on it in the interest of time. We do have the three pillars, the duty to protect, the responsibility to respect, and access to remedies. We do have, I think, we are also aware of the weakness of this framework. This framework is voluntary. This framework does not lend itself to strong enforcement. This framework has issues regarding analytical clarity, mostly how do you distinguish in the real world between negative and positive obligations. The framework focuses on negative responsibilities of companies, whereas in the real world, actually, it's quite hard to separate the two. And in a way, it's increasingly seen as outdated, given the fact that some states have taken the lead in introducing stronger requirements, such as in areas such as due diligence, transparency, etc. What is, however, interesting about the framework and is very much relevant to digital human rights is the idea that the obligations of states, that the responsibilities of companies are independent of the obligations of states. And that is, of course, a very important dimension when we're talking about digital companies that operate at a somewhat transnational level. They're not wedded to any, strongly wedded to any specific national legal system. They interact with many legal systems. And the Business and Human Rights Framework does suggest that they would have their independent responsibilities. And secondly, there is this assumption in the Business and Human Rights Framework that the basic norms of international human rights law, such as those found in the International Bill of Rights, the two covenants from 1966, and some other norms, could be adaptable to businesses. And we will see that, at least with regard to some digital businesses, this translation into digital rights actually could work. Arguably, this is not always the case. So one example of an attempt by a major digital business, which controls important digital rights, to implement the Business and Human Rights Framework is the case of Meta. Meta has voluntarily introduced within its legal infrastructure, which is quite thick. It has terms of service, it has different policies, it has community standards, it has a corporate human rights policy. So they did introduce within their policies and within their laws, that the laws, so to speak, that regulate their activities, they introduce significant human rights contents. They've also internalized human rights standards into the way they internally do business in terms of governance, accountability, oversight. And very interestingly, they did establish a quasi-judicial body, the Oversight Board, which operates as we will see, effectively as a digital rights enforcing body. The Meta Oversight Board is an independent body of adjudicators. About 20 adjudicators serve in this body. They review specific decisions involving content removal or refusal by the company to remove content from the main platforms that are owned by Meta. These are Facebook, Instagram, and Threads. And what's interesting about this exercise is that this looks very much like the activity of a human rights body. I mean, when you read Meta Oversight Board decisions, you will see that the heart of the decision is a human rights analysis that is based on a human rights methodology where the infringement is identified, and then there is a very extensive discussion of whether the infringement can be justified under traditional human rights standards of legality, legitimacy, necessity, proportionality. These decisions often cite international human rights law jurisprudence, including by UN treaty bodies. And effectively, they conceptualize Meta as if it was a state. So they do actually impose obligations on Meta, which are analogous to obligations that states incur in the field of freedom of expression as applied in the digital sphere. Actually, an interesting dimension of these decisions is that Meta situates itself actually as a body that would correct violations that have been effectuated by states. So there are some decisions where the Meta Oversight Board that would say that in countries where there is a repressive government that limits freedom of expression, there is a particular value in allowing online expression on Meta platforms. So the conceptualization is not that the digital rights exercised by companies are a derivative of international human rights law obligations of states, but effectively it reverses the order. I mean, Meta actually supervises the implementation of rights also by states. Having said that, this is a very interesting model, but I will say it's an interesting model that works for one cluster of companies. No other digital rights company has something like the Meta Oversight Board. And it is also dealing with a realm of activity where indeed the analogy between a government and a company makes sense. It would be difficult to extend this to other areas such as generative AI, for instance, or shared economy principles. The other aspect which I want to briefly mention is that we have seen an interest in extending the human rights framework also to the realm of digital rights as applied by businesses offering digital rights. And here we have seen in particular extensive activity by one office holder, which is the UN Human Rights Council Special Rapporteur for freedom of opinion and expression. The main person who has been at the forefront of this is David Kaye, a US university professor, but also his successor, Irene Khan, has also, to some extent, carried the torch forward. And since 2015, David Kaye has been pushing an agenda which would adapt human rights, also developed historically for states, also for companies. And here you see some excerpts from the different very interesting report that he has published, analogizing states to companies, for instance, with regard to allowing encrypted communication, which is, you could say, a new or emerging right or derivative of an existing right to freedom of expression. Extending supervision mechanisms, including state visits, also to companies. Demanding companies in the digital world to also adopt positive measures. So in a way, going beyond the traditional business and human rights framework by actually rejecting this negative, positive rights dichotomy. So they are expected also to allocate resources towards facilitating due diligence and other obligations that the framework introduces. And also specific guidance with regard to access to remedies. The upshot of all of this is that we have, together with other activities by this special mandate holder, and to some extent and to a lesser extent also other mandate holders, we do see a process of gradually expanding a human rights framework to one specific digital right, where maybe the analogy between a state and a business is particularly compelling. Whether this could be extended further on is something that we would have to see. So this brings me to my last slide. And again, I'm moving quite quickly in the interest of time. We do have a framework the Business and Human Rights Framework. That framework also applies to digital rights. However, it is a framework that remains essentially state-centric. And when we move from the state-centric features of the framework, which of course have their own problems, we are in an area where it is still very much voluntary. So Meta has to buy in to the process. Other companies, such as, for instance, Twitter, X, decided to go in exactly the opposite direction and actually dismantle their content moderation apparatus. So this is, of course, a very significant and critical weaknesses. These alternative frameworks, in terms of international law or any other body of law, they tend to be relatively weak and offer limited enforceability. Meta is an interesting and impressive example, but again, I wouldn't read too much into that. Even the Meta process is a drop in the ocean, even with regard to Meta. Very few decisions are actually being reviewed, and millions of decisions are actually being taken without being reviewed. And like I said, this has not been expanded to other companies, either in the digital freedom of expression realm, but certainly not in other realms where digital rights are relevant, right to be forgotten, right to algorithmic transparency, right to a human decision maker, etc. At a more fundamental level, what we are missing, I would argue, is a solid theoretical grounding of what makes digital rights applicable to digital companies. We have a theory, a democratic theory, about which explains the applicability of human rights to states. We do not have a strong theory which explains the applicability of digital rights to big tech companies. There have been some attempts to develop the idea of users' rights, of consumers' rights, but these are not traditional avenues for developing human rights. And in terms of the road forward, one perhaps glimmer of hope is developments in Europe, where we are seeing this increased and you could say constantly increasing interest in regulating businesses, including digital businesses, in ways that encourage them to undertake meaningful self-regulation that would incorporate some human rights standards and some human rights remedial options, although of course much more can be done and should be done in this regard. So I thank you very much for your attention, and I return to you, Ulrike.
Thank you very much, Yuval. Thank you for this very clear and precise overview of the instruments we have, and also the linkage between the private sector and this government responsibilities. We struggle with that a lot on the government side, I have to admit. And just if I may ask my question now, but maybe waiting for your response after the other speakers have spoken, but we really think that there is no such thing as digital space when it comes to rights. So I would be interested on your take on what is digital rights, because the law that, as we have it right now, applies to the digital space. So, but maybe we can comment on that afterwards. And just on an anecdote, because you mentioned Meta quite a bit, in another conference, I had the privilege to talk to a representative from Meta, and she said, please make sure that you educate as many people as you can from the law side and the engineering side in a joint way. And since we are here in an academic institution, I think this is important to mention, and many of you have academic backgrounds with teaching responsibilities. We need lawyers who understand the engineering part, and we need engineers who have a profound legal knowledge. And she said Meta would hire immediately 500 people if they were available on the market. So how is this for some kind of advertisement on the job job market, but I think it's relevant and so also hopeful for young people coming to the job market. So I think this is the way to go. And excuse me for a personal comment here. I would like to turn to Markus Krajewski now. Markus is a professor of law at Erlangen-Nuremberg, and he also taught at King's College previously, also at Potsdam and Bremen. Between 2009 and 2010, he co-directed a program on international trade law, which we just heard about, supporting Ethiopian law schools at Addis Ababa University. He served as a chairman of the board of trustees of the German Institute for Human Rights, which is actually Germany's human rights institution. And I understand he also frequently acts as an expert in the German and European Parliament and advises international organizations, parliamentary groups, trade unions and civil society organizations on international economic law issues and human rights. Great example of the academic and public sector cooperation again. Markus will talk to us about the EU's work on due diligence and supply chains. As mentioned, we've heard quite a bit already about it. I understand from the news channels that we have an important day today in terms of progress and step towards actually achieving this framework and the due diligence directive. So I think it's very timely that you share your insights on this particular topic. Markus, the floor is yours.
Thank you very much, Ulrike, and thank you to the organizers for inviting me, and my apologies for not being there in person, but on the one side, this is the benefit of the new times when we can have these conferences in hybrid manners, but of course it's also the downsides because it makes it so easily to say, well, I cannot be there, but maybe I join online. So next time, definitely I'll hope to be there in person. But the technology, of course, allowed me to present this. So my task was to speak about, the EU's work on due diligence and supply chains. And when I looked at this morning program and I saw a lot of representatives from EU and OECD, I was pretty sure that the work was already mentioned. So I'll see that I also can maybe focus on some particular points. I wanted to briefly speak about the background and the context, but I think I can be very brief on that and then really sort of walk our way through the due diligence directive, its development and scope, content, enforcement, implementation, and then offer some initial assessment. And I'd be specifically interested, of course, in also hearing the assessment of others in the room. So this is a picture which I sometimes use to sort of say, well, what are we actually talking about? And when Yuval spoke, I realized that the examples I give here are, of course, all examples from the non sort of cyber world. We see, of course, oil spilling in the Niger Delta. We see the collapse of the Rana Plaza building. We see, for those of you who are a little bit older, may remember the Bhopal catastrophe in 1984 when there was a huge gas leak. And of course, the collapse of the Brumadinho Dam in Brazil. So just to give us a bit of a flavor of what we're actually talking about. And of course, everybody is aware of that when we look at these corporate human rights abuses and complicity in human rights violations, we face what John Ruggie framed the governance gap. And Yuval nicely pointed out the human rights framework as we would normally apply it. We would sort of look to the state where the human rights abuse took place. We would ask for sort of whether the state has actually fulfilled its duty to protect and then move from there. But of course, we know that that's not the reality in many of these cases. I think we also should be aware of that this is not just a question of certain states, but it's a question of all states. So we will find, I would argue that we find the governance gap when it comes to corporate human rights abuses in all states of the world. And this is also important when we discuss sort of the global implications of this. We do have, of course, some international non-binding guidelines that were already mentioned, the guiding principles, the OECD guidelines, of course, I think may have been mentioned this morning already, the ILO declaration. This is sort of the background here, of course, and I think it's important to realize that because when we look at the due diligence legislation that are now emerging, we should be aware that they are not sort of being developed in a vacuum or in isolation, but rather developed in the context of these non-binding guidelines. So what I have here on this slide is actually a development of national legislation in the EU. And since I'm talking about the EU's development, I focus here on EU member states. Now you may wonder why the UK starts. Now, of course, the UK is no longer a member of the EU, as everyone is aware of. But back when they adopted the Modern Slavery Act of 2015, the UK was still a member of the EU. And so this is, of course, in a way, at the beginning, one could argue of the EU's perspective and the EU's thinking about these questions, when, of course, transparency obligations regarding modern slavery were first established. Then the French Law de Vigilance was adopted 2 years later, which established general human rights due diligence obligations and on environmental harms. A couple of years later, the German supply chain due diligence law, and as you all know, we hate it if we use more than one word to express complicated things in German. So this is why we have a very long word for this, the Lieferketten-Sorgfaltspflichtengesetz, which establishes detailed human rights due diligence obligations regarding both human rights and environmental harms. We have legislative developments. I hear also in Austria, and I'd be interested to hear what the current status there is: Belgium, Finland, Luxembourg, and the Netherlands. There's also legislation in Norway and Switzerland, and of course also legislation discussions, at least in other parts of the world. But I put this here on the slide to suggest this is really something that, from an EU law perspective, needed some attention, to put it mildly. Now, we do have, of course, other existing EU law already. Many of you will be familiar with the conflicts mineral regulation. There's also the now newly formulated corporate sustainability reporting directive, which focuses again on reporting. And then we have the deforestation and forest degradation regulation, which replaces the timber regulation, which is already more than 10 years old. So again, there are developments, very specific developments. And what we have now is, of course, pending law. We have, I just want to mention this, a regulation proposal on the prohibition of products made with forced labor on the market. And here we do have a Commission proposal that was sort of discussed in an agreement in the trilogue, and so the formal adoption of this by Parliament and Council is upcoming. So when we look at the corporate sustainability the due diligence directive, or the EU CSDDD as it's called in the jargon, we should be aware that this is something which is based on international standards, which are not binding, of course, which is in the context of domestic law developments in the EU, but also part of a larger EU picture, looking at specific products, looking at specific production chains, and also as reporting directives. And if you put that into sort of a time frame, you can say that we are moving from transparency and reporting requirements via general due diligence laws to detailed due diligence laws. And I think, when we criticize this, when we analyze this, it's important to realize that that's a certain development going on there. So, as many of you know in the room, of course, this is a development which started a while ago. First, there was an EU-wide civil society campaign. Then the Parliament adopted a resolution with a legislative proposal. The Commission announced that they would do something. Then a little bit later, they actually came up with a directive, a proposal for a directive. And that then went into the normal EU law, legislative process, with the position of the Council and the position of the Parliament, and then interinstitutional negotiations. And then something that caused maybe a little bit of a heart attack to some people, at least. There was an agreement in the trilogues, and normally that then basically means that this is what's going to happen. But then the agreement in the trilogue was not accepted by the Council. Now, we can discuss why this was the case. I would have a couple of points or questions, but from the process perspective, the Council produced a compromise proposal a few weeks ago. The Parliament accepted it. There's been a vote in the plenary, and if I understood Ulrike's comments correctly, we will also probably have a final vote then in the Council today, and then there will be an entry into force process. Of course, it has to be legally scrubbed, and then has to be published in the journal, the official journal. So entry into force, I have not heard sort of any clear predictions, but it's probably going to be the second half of 2024, unless they do it really quick and then they do it the next couple of weeks. Anyway, so I think we can be sure by now that the directive enters into force. What is it? Who does it apply to? It applies to EU companies of a certain size, both with regards to employees and annual turnover. It also applies, and I think this is crucial, it also applies to non-EU companies with more than 450 million euros annual turnover in the internal market. Now, in sort of EU jargon, that's sometimes called the Brussels effect. But I want to point out that this is actually a legislative technique which also applies to the UK Modern Slavery Act. So it's not something that was invented in Brussels. Of course, Commission officials don't want to be told that this was invented in London. But the idea is that if companies are not registered in the respective jurisdiction, but operate in the jurisdiction, then of course there is, and I would argue also from a human rights perspective, there is jurisdiction over these companies, and that you can then actually also apply a new law. Just as a comparison, when the Commission started, it started with much lower threshold of level. The Parliament went even lower than that. And the compromise, so to speak, came out with 1,000 employees. It's clear that this is not a compromise between Commission and Parliament, but this is the Council position. So at the end of the day, I think in many of these points, the Council position then actually prevailed. So what are the obligations? And here I think I can also be quick, because at the end of the day, what we are looking at is a due diligence requirement as established in the principles, the non-binding principles, the UN guiding principles, and others, OECD, that I mentioned earlier. You have to integrate human rights into your company policies. You have to identify and prioritize adverse impacts, basically risks. You have to prevent, mitigate, and remediate adverse impacts. There's a requirement for stakeholder dialogue, a requirement regarding notification mechanism, complaints procedure, monitoring the effectiveness, and then publicly communicate about it. So I think leaving some details aside, but basically speaking, one can say this is what the guiding principles, the second pillar that Yuval talked about, the second pillar of the guiding principles would require from companies. Now, what's interesting is what is the scope of the due diligence obligations? Of course, the guiding principles basically don't make any distinction. The German supply chain due diligence law makes a distinction with regards to own operations, direct and indirect suppliers. The EU directive talks about own operations, operations of subsidiaries, and operations of business partners in a chain of activities, both upstream and downstream. So this is actually quite interesting, that it opens the space to a much wider scope of due diligence than, for example, we have in the German law. When it comes to relevant human rights and environmental standards, the directive refers to an annex, and in the annex, the directive lists the two main covenants. It also lists the Child Rights Convention and the ILO core labor conventions. That's an interesting selection. I was a little bit surprised to see that at the end of the day, the Convention on the Rights of Persons with Disabilities was not mentioned, because that's actually the only international human rights treaty to which the EU itself is also a state party. But that's maybe a detail that can be discussed later. It also mentions a number of environmental conventions when it comes to environmental protection, Convention on Biological Diversity, endangered species, but also a number of quite specific environmental conventions talking about certain products or certain environmental risks and hazards in the context of economic activities. Finally, how will this be enforced? And the directive here is clear and sort of has a dual approach. It has both administrative and civil liability as enforcement instruments. When it comes to administrative enforcement, it requires member states to entrust one or more supervisory authorities with powers to investigate and adopt measures, impose penalties, and so forth. It's quite interesting that the directive also specifically contains the right of natural legal persons to submit concerns to the supervisory authority. So I guess from an administrative law perspective, I would say, well, that's something you can always do. But the directive actually specifically relies on that and tries to link, I would argue, also stakeholder participation complaint mechanisms, not just to sort of companies, but also to the administrative enforcement mechanism. It includes penalties, including pecuniary penalties with up to at least 5% of the annual turnover, so it's not nothing. And most importantly, I would argue on the enforcement side, it also contains a requirement to introduce civil liability if the company's failure to take preventive or remedial measures caused a particular damage, and that damage was not only caused by the business partner. So there will be a lot of litigation in European courts about precisely this question. Now, if we go to the Rana Plaza case, or if we go to the collapse of the Brumadinho Dam, is this a damage that was only caused by the business partner, or is this a damage that was also partly at least caused by the failure of the European company to take preventive or remedial measures? Now, EU lawyers will, of course, know, since this is a directive, it's not directly applicable. It needs to be transposed into EU member states' law. And there's a time period. This is 2 years. That's the normal time period. Interestingly, though, the directive has what I will call a gradual scope of application. So member states are required to transpose the directive into their law within 2 years, but they are only required to sort of apply the law in a sort of 3, 4, and 5 years steps. So very large companies already after 3 years, third country companies 3 and 4, and then only after 5 years, all companies within the scope of the EU directive. So, I mean, if you do the calculation, assuming that this enters into force sometime in the next couple of weeks or months, the 2 years elapse sort of second half of 26, add another 5 years. So we will have the EU-wide level playing field probably in 31, assuming all member states actually transpose this directive into the member state law. One other last point is, of course, this is EU law, so there's apart from the obligation to transpose, of course, there's a general obligation to interpret existing national law in light of the EU directive. So this would be interesting, both for the German and also the French context, where we already have laws which may have to be interpreted in light of the EU directive. A quick first assessment. So I think there are a number of benefits. First of all, we have at least attempts of an EU-wide harmonization. Of course, that actually will depend on what member states do. We have an enforcement mechanism which is based on administrative sanctions and civil liability. So you could say it's more or less combining the German and the French approach. There's an alignment with international guidelines, which I think is extremely important because many companies are already following these guidelines. And it's a signaling effect of legislation towards businesses in global supply chains. Now, will it actually change the situation in many supply chains? We don't know. I mean, we will probably hear some insights in a moment. But I think what we can say is that at least there's a possibility that some business will change their way of doing business. Now, there are, of course, risks. One of the risks I already mentioned, national implementation legislation enforcement could diverge. I mean, this is the EU typical risk. I mean, what if the authority in Germany does something else than the authority in Austria? And of course, there's no global level playing field. I mean, this is an EU approach, even though it applies to non-EU companies, it only applies to them when they operate on the EU market. And of course, and this is the big danger, what will companies do? Will they actually change, or will they basically just, as it's sometimes called, tick the box and say, yes, we've done this, we've done this, we've done this, but not change much? And then, of course, it will not be really worth the effort from a human rights perspective. And I think I'll leave it at that. I'm looking forward to questions and discussion.
Thank you very much. Thank you very much, Markus, also for the precision. One of the best overviews I've seen so far on the due diligence directive, which is a very complicated and difficult animal. And having been quite a bit in the storm of the discussions from both sides, so to say, from the business side and also from those who would like to see more human rights implementation, I must say that it seems now these compromises that you've mentioned seem to make everybody equally unhappy. And usually that's not such a bad sign, actually, as in terms of outcome. So we'll see, as you said, this will take quite a bit of time until we know whether it was worth anything or not. I've also heard on a positive note that, yes, okay, we had to compromise, but this is still better than nothing. So we have now a directive, and this will be transposed into national laws, and it will have some sort of impact. It can always be improved, it can always be fine-tuned, but it's a start. And so maybe we have a good dynamic in this regard. I would be interested to hearing afterwards how you see the implementation for smaller companies, because that was one of the biggest criticisms coming from the business side. Of course, how shall we deal with all these reporting structures and so on? But first and foremost, I would like to turn to Michelle, who is joining us from Latin America, and I would say your contribution will be, to some extent, I would see it almost as indispensable to what we just hear on what the EU is doing, to hear how you see the question of supply chain liability from the viewpoint of the Global South. Michelle, the floor is yours.
Yeah. Okay, can you hear me?
Yes, very well. Thank you.
Okay, thank you so much. Good morning and good afternoon for you in Vienna and Europe. I'd like to begin by thanking my colleague Holger for the invitation, as well as for the supporters of the meeting. And I appreciate the presence of the audience today. It is a great pleasure to join you from Brazil for this virtual session. So my presentation in this human rights and international economic law debate focuses on my ongoing research concerning Brazil's positioning in this new geoeconomic landscape, characterized by intensive competition among major economies and the emergence of China. I'll discuss the current outcomes of the research, which currently raises more questions than provide conclusions. Therefore, I would greatly appreciate any comments and suggestions you may have. My research begins with the identification of a mismatch between legal doctrine and economic operations in the transnational landscape. I will discuss two cases related to the operationalization of transnational economic relations, one involving investments in the soybean agriculture sector and another in the lithium mining sector. Both cases illustrate the centrality of natural resources exploitation, the Brazilian government's ambition to integrate into global value chains, and the highly financialized forms of coordination with the international market. However, they also highlight a significant lack of accountability mechanisms for the true beneficiaries of this economic exploitation and a deficiency in social responsibility measures for the local population affected by these activities. Well, the intensive profile of agrarian and mining exploitation in Brazil is associated with the process of colonization. The intensive mining exploitation process was a central reason for the so-called interiorization of colonization, particularly highlighted in the 18th century for the gold cycle. And the intensive agriculture in turn became its exploitation along the coastal zones in Brazil in the 16th century, but expanded inland in Brazil starting in the 1960s during the military regime. Such relative recent intensive production in agriculture was based on the use of machine and biotechnologies, as well as in the intensification of productive inputs. It is worth noting that these two types of activities were present in the country as a way of occupy the territory and designate its economic role in the world. The nation building, so here we have the text of two constitutions, project was reflected in Brazilian constitutional regulation. The first constitution of the independent Brazil was essentially aimed at regulating the structure of the state and caring for the only common good, which would be the territory and its defense. No other provision disciplined the economic order except for the protection of private property. In 1988, by the end of the 20th century, a significant milestone occurred with the inclusion of a dedicated chapter on the environment of the Constitution, making, for the first time, environmental concerns attain to constitutional status. This provision established constitutional obligations concerning the environment, significant broadening the scope of those responsibility for those that are advocating for its protection, as well as imposing a series of duties on the part of the public power. So environmental protection is now woven throughout the constitutional fabric, spanning from the fundamental rights of citizens to the responsibilities of the federal entities, the regulation of the economic order, and a dedicated chapter in the subject. So, just a minute. Okay. The regulatory framework that we have now for the 20th century was shaped by the aspiration to foster this industrial economy while eradicating lifestyles and production methods that were incompatible with modern standards. So following the 1988 Constitution, that was celebrated as a charter for the citizens and redemocratization movement, Brazil saw the rise of a neoliberal government, starting with Collor de Mello in 1990s, and subsequent administrations pursued reforms that aimed at liberalizing the economy, privatizing public services, and institutionalizing austerity measures. And among these reforms, there was a reduction of public financing for domestic economic activities, and cuts in government spending had a significant repercussion, including in the agriculture and mining sectors. So while investors in those sectors in Brazil vary in profile, they share a common reliance on the growing influence of the financial system that is characterized by diverse structures and highly transnational financial instruments. My idea today is just to highlight a little bit how those instruments are playing a relevant role in those cases. Both cases that I bring here today, they focus on experiences in the Cerrado region in Brazil. That is a central area of the country with drier vegetation, known as the Brazilian savannas, that is kind of less appreciated by its environment and less international targeted, such as the Amazon. And the soybean production occurs in the region that comprises parts of the state that is highlighted here in yellow and dark blue, and have a diversity of forms of occupation of the land. So we have more than 300,000 rural properties, 1,000 agricultural settlements from agrarian reforms, 35 indigenous lands, 36 quilombola territories that are communities that are still closed, consisting of descendants of 19th century runaway slaves. So this is a very complex region that more recently explored this advancement of agricultural exploitation. And with a changing landscape due to the wealth of intensive agriculture and the still very poor people living in the region. The exploitation of the Lydian that is more concentrated in the dark blue triangle also occurs in the Cerrado region that crossing the Jequitinhonha Valley in Brazil, that is a historical site of mineral exploitation known as the poorest index of human rights development in Brazil, that is even nicknamed as by the name of Misery Valley. And there is a fact that the Constitution, in a certain way, disregards this region because it is not named in the Constitution as a protected biome. Then what we see in those two cases is the first one that I will better explain a little bit about not only its historical economic development, but also how the economic supply chain is performing a role there and how financialization gained as a very prominent role in that value chain in the recent years. The soybean production is connected to what was named as a green revolution in the 20th century, thinking about food security in the country and the extensive and intensive exploitation of the land. What we had was increasingly both private and public investments in infrastructure, financing, as well as favorable tax policies acted as magnets, drawing new economic players from various regions within Brazil and from abroad into the soybean industry in that region. Intensive production in that region has undeniably strengthened Brazil's position as a global agricultural leader. Brazil today responds together with the US for 70% of the world's output on soybean. That has been a very important commodity, not only for the world as a whole, but especially for China and its food-intensive consumption. At the same time, it also raised concerns regarding economic diversification, environmental repercussions, and the sustainability of trade model heavily reliant on a single commodity. Reports of pressure on local population and land takeovers have been widespread, prompting legal activists to assist the oppressed. And this has been, the land grabbing topic is a historical topic since the colonization in the country. But still, more recently, it has been also connected to a very intensive and aggressive acquisition of large land parcels by foreign investors. Then Brazil historically had some limitations in the acquisition of land, but in 2010 decided to reinforce the laws and limiting the foreign acquisition. That was an important movement for the reorganization of the supply chain that would be firstly focusing in the farming axis of the supply chain, thinking about in gaining the land, and then had to spread the investments in other parts of the structure of the soybean supply chain market. What is important to note is that this chain is very specific because it's very much concentrated. There is a high concentration of economic power at the global level. So just an example, which just have 3 major industries, transnational seed companies dominating 50% of the global soy seed market. We have three agrochemical companies that control 76% of the global pesticide and herbicide market. And this is very important when we think about how the chain, this economic supply chain is working today. The system in Brazil today is heavily based in a sort of private sort of contract that is named a barter contract, through which there is the issue of a credit instrument that is a crop receipt, where credit is received by the farmer under the obligation of repayment of secured by future crop collateral. So what happens is that global organizers and trader companies have contracts with the supply industries of seeds and agrochemicals and pesticides, and combine that with the financing to the farming. So the local structure is very pressed by those financing instruments that are coordinated into the supply chain for the global market. And this has had an impressive impact in the system in Brazil due to the fact that the government took off the subsidies and all forms of financing that was granted for the farmers before the reforms in the 90s. And more recently, due to the restrictions of acquisition in land, we had a 10 years of gap where investors decided not to invest in land. But nowadays, more recently, what we have seen is that they have transformed the way of getting the control of land through financial structures. They are buying shares of land companies, local land companies, through the capital market, and based on very specific agreements organized in the system. What we see that in the period of 2021, 2022, we have about 25%, a quarter of the production system in Brazil, in the Mato Grosso, is connected to the system of financing of land, and contrasted to less than 5% in the 90s. So again, what we have then in the case of the mining system is also a very similar connection, where we have a new production system of lithium. Brazil is not really a large producer of lithium, but has been moved by this specific branding of the idea of a green revolution based on green lithium to be explored on this one of the poorest regions in Brazil. The lithium exploitation in Latin America, especially in Chile, Bolivia, and Argentina, has been very well explored in the literature. But the case of Brazil holds a particularity due to the fact that Brazil is not a superpower on lithium, but the existence of this mineral combined with other critical minerals with the potential to attract investment in the upstream part of the value chain, and the capacity, or at least the potential, to combine the upstream production with the development of midstream industry connected to the lithium as a source, being the case of electric cars and batteries as part of the energy transition project. So the case analysis is about a company that is named Signa, that is a company incorporated in Canada, benefiting of all the subsidies of green companies in that country, but having as the controller a fund structure of a Brazilian citizen and resident, but other minor shareholders that include large investment funds such as Blackstone. So Sigma invested in this project in the Getulio Valley and intends to have a more clean system of production of the lithium, where they will be cleaning all the outputs of the system of production. But in fact, there has been concerns regarding the expansion into indigenous territories, and there are other facts along the increase of rates of violence, prostitution, that is associated with mining exploitation.
Michelle,
So
may
they
I interrupt? Apologize, but could you wrap up in about 2 minutes or so?
Yes, I can.
Thank you.
So the point is here is different from the agricultural sector. So what I call the attention here, and then maybe this can be combined with discussion of the due diligence analysis under Markus, is the fact that this may have very different local structures in the economic organization of the supply chain. And also the fact that we also have to look at financial actors in those supply chains, not only about the companies that are there. And in the case of Brazil, the structure for the mining exploitation is different in the fact that we have more foreigners exploiting due to the lack of technology of local investors, but we have a very deficient system of supervision or control by the state of the commitments that would be expected under the constitutional regulation. So this is just as a final remark where we get to these questions that are, how can we effectively advance towards this ecological transition that encompasses our present and also future existence? How can we rethink the notions of jurisdiction to involve the responsibility of the true beneficiaries? Because in the case of Brazil, most of the responsibility is designed to think about local people that are residents and based in Brazil. That is not the case of the funds and most of the financial actors. And finally, how can we take our collective responsibility more serious to a more responsive ethical framework that has been, we've seen efforts in the global arena in the last decades, but as we see, they have not been sufficient. And nowadays, what we see are more national efforts in a way of constraining and regulating foreign investments, and also thinking about the foreign investments of exporters of capital in other countries. So thank you very much for your time, and looking forward for the discussion.
Thank you, Michelle. Thank you so much for this great overview of the national situation in Brazil, which could probably, at least at some level of abstraction, also be found in other countries equally. You mentioned specifically agricultural issues, you mentioned mining and matters relating to banks. May I now, when we come to the questions and discussion part, very quickly, unfortunately, start with you and do the reversed order, so to say, to be fair. We have heard today a number of approaches for remedies where it's needed in order to, or we see potential violations for human rights and so on. The High Commissioner has mentioned the need for the reform of the financial architecture on the international global level. There is a working group in the UN of a treaty on human rights and business, which has been there for a while and hopping along, so to say. Maybe the EU directive would bring some new dynamic, but that's another important approach at the global level. We have now the EU directive, which has extraterritorial implications also. We have seen national laws. May I ask for your assessment? What would your take be? Which which approach would be the most effective when it comes to human rights implications and business regulation? Would it be into the financial architecture? Would it be the treaty on the global level? Would it be a regional directive? Would it be the national law? What's your assessment?
I think that first, thinking about the actors that have been the beneficiaries, I would say that financial regulation is really needed. There is the way where they are coordinating the more complex regulations. What we're seeing that for the case of Brazil, we have the companies, the national companies there. In the last crisis that we had in Brazil in the mining exploitation, what we've seen is that local actors have had paid high indemnizations, but they are not the only beneficiaries. There are others. So I think that we should look at those actors at the financial system to think better about how can we think about their responsibility. Secondly, in combining the regulation, certainly a combination of different and a coordination, I think that is one of the topics here, of national and global regulation is the better one, because we have an asymmetry of economic distribution in the world, but not only between countries, but also inside the countries. So I think that we should be aware of those asymmetries and how we can correct them, not only nationally, but also coordinating that globally. I see that today, for example, thinking about food security and energy security, the G20 is getting that in the agenda, but more about on the supplying of those sources, but not thinking about the sustainability of those global value chains in the terms of social and environmental responsibilities.
Okay, thank you. May I ask the other two speakers whether they would like to react to that? Otherwise, I would turn to Markus with another question, but maybe... No? Okay. So, Markus, I mentioned early on the main issue that has been voiced with regard to the potential problem or challenge that the directive will have is the overburdening of smaller companies. Any remedies there? How do you take it? What could be done? How can we best handle this?
Well, I mean, first of all, the question is, what are smaller companies? I mean, I would certainly argue that companies in the EU with more than 1,000 employees and an annual turnover of 450 million euros are not small companies. Now, I think the question relates to that most of these companies that fall under the directive or under the laws implementing the directive would hand down that responsibility in the supply chain to smaller actors. And I think here we need to be very, very careful and not sort of oversimplify matters. Sometimes we have small companies who have an extremely good knowledge about a particular supply chain. I mean, I've spoken to small textile companies who said, well, we know exactly what's going on there, but in other contexts, they may not. So I think we need to really look at it from a case-by-case standard, a basis. And then I would also argue that it is, of course, as always, it is an obligation both of states to support small and medium-sized enterprises with all sorts of form of support, with all sorts of advice. I mean, there's also a role. I mean, we're talking. Virtually we are at the Diplomatische Akademie. So if I see it correctly, maybe many people in the room will become members of the Corps Diplomatique in Austria. And then, of course, a question is, well, what is the role also of the foreign services of the member states? So, I mean, if an Austrian company says, well, my supply chain ends in India, I would see partly also a role of governments to say, well, of course we can furnish you with some knowledge. We have some insights. I mean, there are details to be discussed and everything. There may be chambers of commerce that can be sort of also taken into account. And then, of course, it's also a role of the larger companies not to just hand down sort of questionnaires. I mean, I've spoken to small and medium-sized companies, and I said, now we receive questionnaires from all our sort of business partners. There's one from Mercedes, there's one from Volkswagen, there's one from, and of course that needs to be coordinated. I think so. We should take these things seriously, and maybe sending out questionnaires to your suppliers is not what the due diligence actually requires you to do.
Thank you very much, Markus. I think we will probably be engaged with these questions for a number of years, and indeed, yes, we are aware at the state side that we have a role too, but it's a shared responsibility, and this is particularly acute, I think, in this aspect. Now, returning to Yuval, last but not least, sorry for waiting. The question on digital rights, totally fascinating, I think. How would you go about this? Do you think there is such a thing as digital rights? And you mentioned actually yourself that the word translation of rights is maybe the key here. Could I ask you to return to the beginning of the day where we started out with technology, on your take on that?
Yes, so I actually think it's a very good combination that you've had here of very specific cases and regulatory initiatives, and then dealing perhaps with some of the more abstract or conceptual issues. So yes, there are such things as digital rights. You could say that probably we are alluding under this title to a number of things. So there is one meaning of digital rights is simply that some of the basic rights that we have are now simply implemented or practiced in a digital context using digital technology. So in that regard, online freedom of expression is a form of freedom of expression that is mediated through digital means. But that means that although conceptually it's still freedom of expression, it is applied in a very different way because of scale, speed, scope, for instance, considerations. Also, in terms of access, in terms of impact. So this would be one dimension, but there is also a dimension where you do have digital technology developing certain needs or certain areas of the human rights discourse that were previously not existent before. So the right to be forgotten, for instance, is a right that is a digital right because before digital technology made it so easy to retrieve information about us, we had no practical reason for that right, and the same would go probably for algorithmic transparency or the right not to be subject to automated decision making. I mean, these sort of, or maybe even the right to internet access. I mean, these sort of new needs, new interests that are relevant for digital technology users and other individuals impacted by digital technology have their own logic. And finally, one could maybe say, and this is perhaps the area, I mean, this is the general direction that I was moving in, that this is not only, whereas when we are thinking about traditional human rights, we are thinking mostly about rights that are have as a correlatory state obligations. When one is talking about digital human rights, I think we're increasingly also thinking about the technology companies as the immediate duty holders, and that requires us to think very differently about this field.
Thank you very much. So it's also not only the quality of the right itself, but also who does it apply to, and that's an interesting aspect, of course.
And maybe you could also say, and I don't have time to expand on this, but maybe also new right holders. I mean, we can also think of virtual entities as right holders, and avatars and all these sorts of metaverse related dimensions. They may have their own sets of rights that we haven't really encompassed within the traditional human rights framework.
Yeah, and I would immediately add here rights and obligations. And of course, this I think would indeed bring us to an entire new conference topic. Professor Estermeier, maybe next year this time we can expand on this and probably fill a day or two on the various aspects of that. If I understand the organizers of the conference correctly, in the interest of time, since we are overdue already, we skipped the possibility for questions and answers from the floor. However, if there was anything you wanted to hear or respond from the panelists, there is the possibility maybe to forward emails and transfer them and so on. So apologies for that. That it's we are in a somewhat tight framework. I would like to convey my heartfelt thanks to the speakers who I think have covered a lot of interesting aspects of business and human rights. And with that, I would like to conclude the panel and give back to the organizers. Thank you very much.